Back to the podium. He most recently spoke to the association in October of 2016 when he spoke on the Halifax Relief Commission, which a history that he has since completed, I believe, on the Halifax Relief Commission. Barry describes himself as a retired provincial civil servant and a full-time student of history. Barry holds degrees from Dalhousie and Oxford University. He has broad historical interests, not only the Relief Commission, but the history of the Nova Scotia Barristers Society, the biography of Frances Fish, Nova Scotia's first woman lawyer. He was the researcher for the Nova Scotia Home for Coloured Children Restorative Inquiry, and now he's working on this scholarly biography of Lorne Clarke, which is the basis of the paper here tonight. So I turn it over to you, sir.
And you won't be applauding when I'm finished. I struggle over the title of the paper. I'm not sure it's, anyway, I'll share it with you. In quotes, Malagash man. I was prompted to go down that road when I was looking at some items in allnovascotia.com under the late former Chief Justice's name. And they had him born in Pictou, which caused quite a stir. His wife was from Pictou. He was from Malagash. I want to emphasize that. On March the 27th, 1995,
could you
in the foyer of the law courts on Upper Water Street, the Lieutenant Governor of Nova Scotia unveiled an inscribed plaque, granite plaque erected by the last serving members of the recently defunct Halifax Courthouse Commission. The inscription bears the names of Nova Scotia's Chief Justices up to and including the current one, the Honourable Lorne O, Clarke, who had held office since 1985. The first Chief Justice was Jonathan Belcher, whose appointment in 1754 brought the Supreme Court into existence. Belcher was appointed by the British Home Government, as were all his successors up to 1848, after which, for 20 years, judicial appointments were made by the province. The provincial system came into effect on the achievement of party political, as we like to call it, responsible government, that's debatable, and lasted until 1867, when Section 96 of the Constitution Act vested the appointment of superior district and county court judges in the federal government. Jonathan Belcher and Lorne Clarke are as alpha and omega. They are the only two Chief Justices of Nova Scotia for whom a claim of historical significance in respect of the office can be made. This is not to say that the other Chief Justices lacked historical significance, but it is due to their accomplishments in other spheres of activity, usually politics. Unlike his successors, who were involved in politics before their elevation to the bench, Jonathan Belcher's political activity took place entirely after his appointment. As Chief Justice from 1754 until his death in 1776, Belcher was beset by challenges far greater than those faced by any of his successors before Clarke. An expatriate New Englander who had spent most of his career in England and Ireland and had next to no experience of colonial law and politics, Belcher set up a professional high court at the time of judicial crisis, when there were lawyers at the bar but none on the lower bench, and criminal justice was being administered by the governing council, none of whom was a lawyer. He also wrote the statute laws, determined the extent to which English criminal law would be, quote, received, unquote, in the colony, served as the governor's chief public policy advisor, reconciling him to the inevitability of establishing a legislature and providing the legal rationale for the expulsion of the Acadians. He revised the statutes enacted by the legislature and served for 3 years as head of government on the death of Governor Lawrence, during which time he negotiated a permanent peace with First Nations people while running afoul of the mercantile elite who secured his removal as lieutenant governor. He is the father of Nova Scotia's legal system and a major figure in the government and politics of the colonial era. If Jonathan Belcher was creator, then Lorne Clarke was redeemer, also taking over the Supreme Court at a time of judicial crisis. In the aftermath of the Donald Marshall Jr. scandal, he helped restore both the reputation of the court and public confidence in the judiciary. As Chief Justice, Clarke also presided over the most significant restructuring of the courts since the founding of the Supreme Court, namely the 1993 merger of the County Court and the Trial Division of the Supreme Court into a new integrated Supreme Court, and the establishment of a separate Nova Scotia Court of Appeal. Over the course of his 13 years as Chief Justice, legal history was made, and it was often Clarke himself who was making it. He was a Chief Justice who reshaped the legal culture of Nova Scotia and whose influence on the provincial justice system was indeed transformative. In a time of post-traumatic stress affecting the judiciary, he stood out as the dynamic leader of a court under fire. A junior judge of the Trial Division, promoted Chief Justice of the province, he soon showed himself to be a great judicial leader whose sang-froid, moral suasion, and common sense realism helped restore the credibility of the superior courts. The early 1980s saw the birth of Canadian legal history and the consequential rebirth of Canadian judicial biography. The year 1984 saw published both David Williams's biography of Sir Lyman Duff, Chief Justice of Canada, and Patrick Broad's biography of Sir John Beverley Robinson, Chief Justice of Upper Canada. These were the first scholarly biographies of Canadian jurists. The following year saw the publication of Dennis Grunding's biography of Justice Emmett Hall of the Supreme Court of Canada. In 1991, Gordon Bale published his biography of New Brunswick Sir William Johnston Ritchie, second Chief Justice of Canada. The years since have witnessed a veritable renaissance of scholarly judicial biography. We now have Boyer on Chief Justice McRohr, McConnell on Justice McIntyre, the Supreme Court of Canada, Anderson on Justice Bertha Wilson, the first woman appointed to the Supreme Court of Canada, Sharp and Roach on Chief Justice Dixon, Gerard on Chief Justice Laskin, Vaughan on Justice Hall, Kaplan on Justice Rand of the Supreme Court of Canada, and most recently, and if I may say most significantly, Constance Backhouse on Justice Claire Leroux-Dubé, the second woman appointed to the Supreme Court of Canada. No Chief Justice of Nova Scotia, except Sir William Young, has received a scholarly biography, and I want to point out that that was produced by my good friend Bill Lawrence in his doctorate at Dalhousie. Jonathan Belcher certainly merits one, as does Lorne Clarke. My biography of Chief Justice Clarke will examine identity formation, farm boy, precocious law student, law teacher, political animal, and near politician, small-town lawyer, and labor arbitrator. Like Professor Backhouse's life of Justice Leroux-Dubé, it will attempt to move beyond conventional judges' biographies which highlight the big cases and legal legacy, exploring the social, political, and jural context in which Clarke's somewhat unlikely career developed. He was not born to the purple. He began his career as a law teacher and intended to remain one. He was not a famous trial lawyer or appellate counsel. Though politically active before appointment to the bench, he never ran for political office. He never practiced with one of Halifax's big firms. He was never president of the Law Society. In some respects, Clarke's career path was littered with anomalies. Despite these anomalies, perhaps because of them, the scholarly biography of him can contribute to a better understanding of legal education, the legal profession, the judiciary, the Supreme Court of Nova Scotia, and perhaps the most difficult moment in its long and largely uneventful history. The role of politics in judicial preferment, the position of small-town lawyers in a profession dominated by the elite urban bar, the inner workings of a provincial top court, changing conceptions of the role of a provincial chief justice, and the experience of lawyers who carve out a niche for themselves but who do not occupy the front rank. Professor Backhouse is right to observe, quote, "We tend to have settled notions about the careers of famous lawyers and judges," unquote. But Clarke defies the typical narrative. Rather than getting his start in a comfortable middle-class family, he was the son of a farmer and the first member of his family to attend university. His private life was straightforward. Though an only child, he was part of an extended family with whom he dutifully kept in touch. His wife, the former Mary Louise MacLeod, a fellow Dalhousian and Presbyterian whom he met at church in Halifax, became a well-regarded social worker who, complying with the standards of the time, abandoned her professional career upon marriage in 1959. They were together for 48 years until her death in December 2007. As he rarely appeared in court, Clarke's flourishing practice was not based on his prominence as advocate and counsel, and he can hardly be said to have been, quote, elevated to the bench with the support of the wider legal community, unquote, and that's from Constance Backhouse. Other factors, chiefly the politics of patronage, were in play. As a lawyer, Clarke was not especially well known in the wider legal community, and unlike some lawyers, he made no special effort to become so. Lorne Clarke's work as a labor arbitrator, conciliator, and mediator spoke for itself. The first and only child of a farming family in the small rural community of Upper Malagash in northeastern Cumberland County, Lorne Clarke was 16 years old when he arrived at Dalhousie University in the chaotic autumn of 1945. He was too young to have been a veteran himself, but the small campus was bursting with returned veterans resuming or taking up higher education. It seems probable that by the time he arrived at Dalhousie, Clarke had made up his mind to get into law school as soon as possible, the classes of the first year counting towards the BA as well as the LLB. He graduated BA in 1949, History and Economics, and LLB in 1951. By the time Clarke was called to the bar in August 1953, his career had taken a new and unusual turn. In 1952, he was appointed assistant professor at Dalhousie's Faculty of Law, unheard of for a recent graduate who was not even a member of the bar. But Clarke taught corporate law, among other things. He was mainly remembered for his championing of the mock parliament, an ancient and venerable institution which spoke to his interest in and attraction to politics. In the words of the law school's historian, Clarke, quote, stayed with the school long enough, namely 7 years, to make a contribution, unquote, latterly serving as secretary of the faculty. In 1957, on the strength of an LLM from Harvard University, he became a tenured professor. Among his students was Bertha Wilson, LLB 1957, for whom Clarke helped find an articled clerkship position in Halifax. A bred-in-the-bone conservative, active in party circles throughout his years at Dalhousie, by the time he was called to the bar in 1953, Clarke was recognized as a rising star in the political firmament. The federal election that year saw Percy Chipman Black, longtime Conservative MP for Clarke's home county, retire. Local Conservatives, desperate for a credible candidate, tried to recruit Clarke, but that would have meant abandoning his plans for postgraduate study at Harvard Law School. He accordingly declined to let his name go before the nominating convention. In the general election of 1957, Clarke could have had the federal Progressive Conservative nomination in Cumberland for the asking. Doing so, however, would have meant giving up his job, leaving Halifax, and returning home to practice law in a small community already overstocked with lawyers. The ramifications proving too great, Clarke again decided against allowing his name to stand. The nomination went unopposed to one Robert Coates, a young Amherst lawyer who easily defeated the Liberal incumbent and went on to hold the seat continuously for 30 years, eventually becoming a cabinet minister. The wisdom of hindsight induced Clarke to wonder whether he had made the right decision. Though he remained politically active until his appointment to the bench in 1981, he never again seriously considered standing for political office. Nor did Clarke attempt to combine practicing law with law teaching, abandoning the latter in 1959 when he married and moved to Truro, a town with which neither he nor his wife had any connection. He had been offered a place in the gilt-edged conservative law firm Patterson, Smith, Matthews, and Grant, whose head, Ike Smith, was a minister in the Stanfield government. Making partner within the year, Clarke was appointed Queen's Counsel in 1969. He specialized in labor relations, a new area of practice in post-war Canada, making his professional reputation provincially, regionally, and even nationally as a provider of advisory, conciliation, and arbitration services. In 1969, having retained no less a figure than John J. Robinette as senior counsel, he triumphed in the Supreme Court of Canada in Casey versus Automobiles Renault Canada Limited, in which a judgment for damages for malicious prosecution was reinstated after having been overturned by Nova Scotia's appeal court. He also served on the Nova Scotia Law Reform Commission for most of the 1970s, but did little court work beyond the corporate, commercial, and probate. Clarke's reputation stood so high that in 1980, a seat in the trial division of the Supreme Court was created for him by the John Buchanan government. While the provinces control the constitution, maintenance, and organization of the courts, the higher courts, Ottawa controls who was appointed. Despite the Liberals being in power federally and Clarke's being a pronounced conservative, he was appointed in February 1981 by then Minister of Justice Jean Chrétien. Such a step was and is nearly unheard of, and begs the question why. It was an eventful time in the history of the Supreme Court of Nova Scotia. Chief Justice Gordon Cowan of the Trial Division retired in September 1981 and was replaced by fellow Liberal Constance Glooby. A student of Clarke's in law school, she was the first woman appointed to the Supreme Court of Nova Scotia in 1977 and the first female Chief Justice in the country. Clarke's highest profile jury trial was among his earliest. 2 Dartmouth police officers charged with second-degree murder resulting from the death of a suspect during the course of an arrest. R.V. Cluett ran for 6 weeks and quickly became a cause célèbre. One officer was convicted of manslaughter while the other was acquitted. The appeal court set aside the acquittal on the grounds of misdirection by the trial judge. But the Supreme Court of Canada, on further appeal, reinstated it. The outcome killed any lingering doubt that Clarke, a solicitor who had rarely, if ever, seen the inside of a criminal court, was not up to conducting criminal trials. He was a dangerous man to underestimate. Clarke also presided in 1983 at the first of the 3 trials of Roy Ebsery for the killing of Sandy Seal, for which Donald Marshall Jr. had previously been convicted and imprisoned for 11 years. Despite his best efforts to persuade the jury to persevere with their deliberations, they were hopelessly deadlocked and Clarke had to declare a mistrial. Chief Justice Ian McKeegan, in office for 12 years, elected to go supernumerary, semi-retired, on 1 June 1985, His reputation and that of the appeal division over which he presided had been badly tarnished, one might say compromised, by the Marshall reference, which vacated the conviction of Donald Marshall Jr. For murder which he had not committed. The justices who sat for the appeal, though acquitting Marshall, stated in their judgment that any miscarriage of justice was more apparent than real. Such language against an innocent victim of the criminal justice system caused a sensation and led to calls for a public inquiry. The furor undoubtedly contributed to McKeegan's decision to semi-retire. In the normal course, the succession would have gone to Gordon L.S. Hart, senior member of the Appeal Division and acting Chief Justice. But the circumstances were anything but normal. The justices on the Marshall reference had ruled themselves out of contention by their conduct of it. Hart was also a Liberal and a Liberal appointee, a distinct disadvantage after the Progressive Conservatives returned to power in Ottawa in September 1984. The same handicap applied to Constance Glubig, since 1982 Chief Justice of the Trial Division. Predictably, the vacancy at the top set off a feeding frenzy among Nova Scotia's conservative lawyers keen to reap the rewards of their party's return to power federally after nearly 20 years in the political wilderness. Lorne Clarke was in the right place at the right time. His political credentials were impeccable. He enjoyed the confidence of the federal and provincial governments, both then progressive and conservative. He was untainted by the Marshall scandal. He had served most creditably in the trial division, if only for a short time. And it was customary that the Chief Justice be appointed from within the Supreme Court. These considerations combined to make his appointment inevitable. In February 1985, Kenneth Matthews, the head of Clarke's law firm, a former law firm, and a very prominent conservative, was appointed to a newly created seat in the Appeal Division. 6 months later, Clarke was promoted Chief Justice. He took over the Supreme Court at the lowest point in its 230-year history, a nadir symbolized by a tragic event 6 days before his appointment. The precious library of Dalhousie Law School was largely destroyed in a devastating fire. Fallout from the appeal court's begrudging acquittal of Donald Marshall Jr. was spreading, and calls for a public inquiry into his prosecution and wrongful conviction were daily becoming louder. The first few years of Clarke's tenure as Chief Justice were overshadowed by the Provincial Royal Commission on the Donald Marshall Jr. prosecution and its damning report issued in January 1990. Concerned that justice must be seen to be done and anxious that no further reputational harm be inflicted on the Appeal Division over which he now presided, Clarke took decisive action. In addition to recusing himself from participating in Roy Ebsery's second appeal, he also prevented Justice Leonard Pace, who had been appointed to the Appeal Division in 1978, from sitting on the panel. Pace had been Attorney General when Donald Marshall was tried and, inexplicably, also sat for the Marshall reference. When the Commission's ruling to limit the compellability of former provincial cabinet ministers to testify before the inquiry was successfully challenged in the trial division and appealed, Clarke exercised his powers under the Judicature Act to constitute the appeal panel by drawing the justices from the trial division, a creative solution. He adopted the same tactic in McKeegan versus Hickman, afterwards a leading case in judicial independence, when the Commission's subpoena to the justices who sat for the Marshall reference to testify was successfully appealed and ultimately quashed. Clarke's negotiation of the Marshall Inquiry report began the process of restoring the credibility of the court. Throughout, his aim was to preserve the court's integrity so that he could proceed with rebuilding it from within. The final act took place in 1990, shortly after and indirectly as a result of the release of the report. which severely criticized not only the Marshall reference decision, but also the, quote, propriety of Justice Pace sitting on the reference, unquote. The justices, excluding McKeegan, who was mandatorily retired by age in April 1990, and Pace, who resigned the same month, were subjected to a formal inquiry by the Canadian Judicial Council requested by the Attorney General of Nova Scotia. As an ex officio member of the CJC, Clarke did not participate, of course, and the inquiry committee declined to recommend that any of the justices be sanctioned. Though unsympathetic to the inquiry, which he believed should not have been requested or initiated, Clarke recognized more clearly than anyone that the court must reform itself from within by setting new and higher standards of judicial ethics. As Chief Justice, he was determined to lead from the front and to be seen to be doing so. The first half of his 13-year tenure may be described as strategic management, a form of damage control, actually, with, I think, a view to preventing the recurrence of another Marshall. Though the Marshall Inquiry report made no recommendations specifically affecting the Supreme Court, its implications were clear. Clarke recognized that decades of inefficiency, the court was poorly administered, under-resourced, and in desperate need of restructuring to eliminate jurisdictional anomalies, had a sustained negative impact on its effectiveness. No sooner had the Marshall Inquiry report been issued than the Attorney General announced the establishment of a task force on the structure of Nova Scotia's courts. Chaired by a former dean of Dalhousie Law School, Bill Charles, and numbering among its 10 members both the head of Clarke's former law firm as vice chair and one of its partners. The task force's 450-page report was issued in March 1991. It led the following year to the Court Reform Act, which introduced wide-ranging amendments to the Judicial Act. Though he could not, of course, play any public or credited role, Clarke's behind-the-scenes brokering advanced if it did not drive the initiative to divide the trial and appeal divisions of the Supreme Court into two separate courts. An area in which Nova Scotia lagged well behind the rest of the country, the reconstitution of the Supreme Court was Clarke's greatest but least visible or acknowledged achievement. It is also the most significant legacy of the Marshall Inquiry. The appeal court during Clarke's tenure did not flinch from addressing controversial and divisive social issues, such as French language instruction in schools in majority Anglophone communities, Lavoie versus Nova Scotia. His most important decision, R.V. Denny, established that hunting and fishing by First Nations people for subsistence is a constitutionally protected, quote, existing Aboriginal and treaty right, unquote, which had not been extinguished. The judgment made law, and Clarke's reasoning was followed by the Supreme Court of Canada in Sparrow, the leading case. Scarcely less important was RV Nova Scotia Pharmaceutical Society, where the appeal court reinstated the conviction overturned on Section 7 grounds of the Charter, life, liberty, and the security of the person, and on further appeal was upheld by a unanimous Supreme Court of Canada. Clarke rendered judgment for the court, and the case became a leading one on the doctrine of vagueness. Clarke concurred in the 1993 judgment overturning the injunction granted by Chief Justice Glooby of the Trial Division stopping the West Ray Mine public inquiry, as well as in the 1995 judgment overturning the state of proceedings ordered by Justice Robert Anderson in the trial of the mine managers for manslaughter and directing a new trial. He also concurred in the unanimous judgment in McDonald v. Momberket, disallowing vicarious liability on the part of the Roman Catholic Church in respect of sexual abuse of minors committed by its priests, quote, a landmark ruling, unquote. As shrewd a judge as Clarke was, he was not always right. In 1994, he rendered judgment for a unanimous court upholding the wrongful first-degree murder conviction of Clayton Johnson. 4 years later, the Federal Minister of Justice remitted the case for reconsideration by the Court of Appeal, and in 2002, Johnston's conviction was quashed. The similarity to Donald Marcel Jr., whose wrongful conviction for murder was also in the first instance upheld by the appeal court, is uncanny. Unlike his predecessors, Clarke took an expansive view of the obligations and opportunities of his post. The Chief Justice was not only a first among equals on the appeal court, but also head of the provincial judiciary, whose chief responsibility was to lead, and to lead by example. Creative, in the sense in which that term is not usually applied to senior judges, his true genius was for innovation and reform. He aimed to improve performance standards by re-educating the judiciary. Judicial education lay especially close to Clarke's heart, the more so in that Recommendation 33 of the Marshall Inquiry Report called for leadership in that area, which hitherto had been conspicuously lacking. Clarke's response was to invite all judges in the province to a 3-day continuing education seminar in Halifax in February 1992, the focus of which was to develop social context awareness. In 1991, he joined the board of the National Judicial Institute, founded in 1988 to provide continuing professional development for judges. At a time when cultural awareness and sensitivity training for judges was unheard of, continuing professional development was one of Clarke's priorities, as were judicial ethics and accountability, restorative justice, and access to justice. On the cusp of the 21st century, Clarke strove to bring Nova Scotia's judiciary fully into the 20th. The year 1988 saw the establishment of a provincial judicial advisory committee to recommend to the federal minister lawyers suitable for judicial appointment. In 1992, Judge Elizabeth Roscoe became the first woman appointed to the appeal court. Nancy Bateman followed in 1995. That year also saw the inauguration of a 15-month pilot project in which lawyers graded by anonymous survey the judges before whom they appeared. About 2/3 of the province's 79 judges participated in this continuing professional development project, as did Clarke himself. It was unique in Canada and sufficiently controversial that it was not repeated. He inaugurated as well an annual province-wide consultative chief judges conference, which led in 2002 to the establishment of the executive office of the judiciary. Clarke also set up a media liaison committee, provided media representatives with dedicated space for law courts, permitted the use of cameras and audio and video recorders during appeal proceedings, and authorized the automation of the courts. As Chief Justice, Clarke was in tune with the times, determined to shake up Nova Scotia's unreformed and unreconstructed judiciary, which had been responsible for the abuses to which the Marshall Inquiry Report drew attention, and to instill in senior judges the necessity to engage constructively with modernity. Clarke's 13 years as Chief Justice also witnessed generational transition from judges like himself, born in the 1920s and 30s, to those born in the 1940s and 50s. As if this were not enough, Clarke played a most active role on the Canadian Judicial Council, where he served as second vice chair from 1992 to 96. His relations with Justice Frank Iacobucci, formerly Chief Justice of the Federal Court, were especially warm. Clarke had the satisfaction of seeing both of his sons called to the bar, another member of his former law firm appointed to the Supreme Court, and his protege, Professor Thomas Cromwell, who's been much in the news these days, appointed to the Nova Scotia Court of Appeal in 1997. That year also brought speculation that Clarke, despite his age, 69, would be elevated to the Supreme Court of Canada in succession to Justice Gérard Laforêt of New Brunswick. Atlantic Canada's representative on the court since 1985. Having been head of one high court, however, Clarke was uninterested in becoming junior associate Justice of a hire, despite his being far and away the most prestigious candidate from the region. Nova Scotia's turn, as it were, the first since a Halifax conservative lawyer, Roland Ritchie, was appointed in 1959, reverted to New Brunswick, from whose Court of Appeal, Michel Bastarache, a fluently bilingual francophone 20 years Clark's junior, was elevated to the High Court. Clarke announced his retirement in May 1998 to take effect June 30th. It was expected by no one and lamented by all, the more so in that Clarke did not publicly explain why he stepped down so suddenly for no apparent or stated reason. Surprise and disappointment soon gave way to gratitude for the magnitude of his achievements. His announcement preceded by 2 weeks the opening of the first session of the new legislature after the recent provincial election. The speech from the throne included an eloquent tribute which credited Clarke with restoring Nova Scotians' faith in their justice system. Unlike McKeegan, he made a clean break and elected not to go supernumerary. Apart from McKeegan, moreover, not since 1915 had a Chief Justice stood down except through mandatory retirement or death. The Liberals having returned to power in Ottawa in 1993, Chief Justice Luby, a Liberal and a Liberal appointee, succeeded Clarke. Clarke soon joined ADR Chambers, that's Alternative Dispute Resolution, a Toronto-based association of, quote, retired judges, experienced lawyers, and other dispute resolution professionals dedicated to assisting the legal and business communities to resolve disputes in an expeditious and cost-effective manner, unquote. One of only 2 members from Atlantic Canada, the other was senior counsel Neil McKelvey of St. John. Clarke found this work congenial. He also resumed attending progressive conservative political meetings, which he could not have done had he elected to remain supernumerary over the years before he reached mandatory retirement. In September 1998, Swissair Flight 111 en route from New York to Geneva crashed into the sea off southwestern Nova Scotia with the loss of all 229 persons on board. The provincial government decided to honor the memory of the victims in a grand manner. In November, Clarke was appointed chair of the Swissair Memorial Planning Committee, which oversaw site selection, planning, and design of the memorial and interment of recovered remains. This assignment consumed a year of Clarke's life. His determination to involve relatives of the victims complicated the work. He could not please everyone, nor did every victim's family wish to be involved. In the public mind, however, this is the achievement for which Clarke is best known. A grateful province included him among the first group of recipients of the Order of Nova Scotia in 2002, while the Dalhousie Law Alumni Association conferred its prestigious Weldon Award for unselfish public service on him. No sooner was he done with the Swissair Memorial Planning Committee than Clarke was invited in October 1999 to chair the ad hoc statutory arbitration panel established when the new progressive conservative government of Dr. John Hamm legislated the province's 650 striking paramedics back to work. In December 2007, Clarke lost his wife of 48 years. A month later, in his 80th year, he undertook the most difficult and demanding assignment of his professional life off the bench, chairing the 3-person panel to determine, as between Canada and Nova Scotia, the balance of Crown share adjustment payments. This was unfinished business left over from the Canada-Nova Scotia Offshore Petroleum Resources Accord of 1986, which had afterwards bedeviled relations between Ottawa and Halifax for 20 years and was as politically sensitive as it was important. Nova Scotia had scarcely benefited from its offshore petroleum resources until February 2005, when the new Atlantic Accord promised finally to pour hundreds of millions of dollars into the province's debt-ridden economy, effectively giving the province exclusive control of offshore revenues. The ground shifted, however, after the Conservatives returned to power in Ottawa in January 2006. The new government of Stephen Harper decided that Nova Scotia could not have its cake and eat it. There would either have to be a new formula or equalization payments would have to be recalibrated in order to take into account revenues from offshore petroleum resources development. The 2007 federal budget killed the federal provincial arrangement, as the Atlantic Accord was officially known, and led to a showdown between Halifax and Ottawa. In October 2007, however, a compromise was effected whereby Nova Scotia could choose a different equalization formula from what had been offered in the federal budget. The details were to be worked out by an independent panel, which would report by March 2008. The panel was not appointed until January, however, and 2 months were insufficient for it to complete its work. It lacked not only time, but resources, and the members could not agree among themselves. The federal representative predictably wanted more for Ottawa, and the provincial representative more for Nova Scotia. Clarke's recommendations as chair and impartial umpire occupied the middle ground and became, for all practical purposes, the panel's report. That was Lorne Clarke's final public service. Over the following 8 years, he declined gradually and gracefully, dying in his 88th year in May 2016. The public response was remarkable. His very active and high-profile post-retirement career had kept him in the public eye over the decade from 1998 to 2008. He had seemed always to be working, as if he were not retired at all. Chief Justice Michael MacDonald led several present and former judges at Clarke's funeral held at Halifax's Presbyterian Church of St. David's, where Clarke had become a member of the Kirk Session at age 25 in 1953, while assistant professor at Dalhousie Law School. Members of St. David's remembered with affection his mordant sense of humor, such as his appearing at divine service wearing papal red shoes. An eloquent and moving eulogy was delivered by Justice Thomas Cromwell, formerly of the Supreme Court of Appeal, Nova Scotia, Court of Appeal, whom Clarke had the pleasure of seeing appointed to the Supreme Court of Canada after the retirement of Justice Bastarache in 2007. Shortly before leaving office, Clarke had initiated the process leading to the celebration in 2004 of the 250th anniversary of the appointment of Jonathan Belcher as Chief Justice. A volume of scholarly essays published on the occasion included one which, under the heading Heightened Expectations, 1982 to 2004, described Clarke's tenure thus, and these are the words of my friend, Professor Philip Gerard. In the wake of the Marshall Inquiry, morale at the Nova Scotia Supreme Court was probably at an all-time low. Lorne Clarke, Chief Justice since 1985, proved to be the right person to take on the task of rehabilitation. Chief Justice Clarke embarked on an ambitious campaign designed to make the Nova Scotia courts national leaders in judicial education, public accessibility, and accountability. He aimed constantly to reach out to others, to other courts, to the bar, to academe, to the public at large, with the goal of making the courts more transparent and learning where they could improve. Chief Justice Clarke promoted continuing education for judges on substantive law issues and was an early leader in the field of social context education, initially resisted by many judges across the country. Most importantly, Lorne Clarke's humanity, empathy, and common touch had a therapeutic effect on his court and helped him begin the process of restoring Nova Scotians' confidence in their judiciary. The title of a symposium arranged in honor of his 1998 retirement, spoke to his principal preoccupations: law, justice, and community. Sponsored jointly by the Nova Scotia Barristers Society, the Nova Scotia branch of the Canadian Bar Association, Dalhousie Law School, and the judiciary, the symposium was held at Dalhousie Law School on April 17th, 1999, and video recorded. Themes and presentations alike spoke equally to Clarke's principal concerns: the public interest, public values, and the administration of justice in the 21st century, law and justice, rights and responsibilities, the legal system and the community, alternative dispute resolution and professional responsibility, the legal system and the community, restorative justice and law, justice, and the community, the way ahead. As one wit commented during the course of the banquet following, at which Justice Frank Iacobucci, then of the Supreme Court of Canada, delivered the keynote address, "There are many Chief Justices in the room, but there is only one Lorne Clarke."
We have questions? Yes, sir.
Barry, who made the statement about Marshall that he was the author of his own misfortune?
This occurs in the course of the reference, and again, that's a technical term. It's not an appeal. It simply means that the Federal Minister of Justice refers a case to the appeal court. And it's in the report. If you read the published report of the Marshall reference, you will find it there. And that, of course, is why the Marshall inquiry, the commissioners were so keen to find out who had actually written it. And that became a huge, of course, legal case, and went all the way to the Supreme Court of Canada, and the justices of the appeal court were spared from having to own up to who had written what and where exactly that turn of phrase originated.
Yes, sir.
Question regarding the Marshall Commission recommendations. I don't remember Chief Justice Clarke ever appointing an invisible or visible minority to the bench. And I question whether he did anything regarding those recommendations.
I would have to agree with you. I mean, at that time, where you didn't even have a woman on the court, let alone a representative of the visible minority community, he couldn't do everything at once. And I think he did as much as he could, given the other the other factors, if I may so express myself. I certainly concur with the point you're making. It's a fair point. But I think if you look at his achievement in context, he was really pushing the envelope. He was going much further than just about anyone else would even ever thought to go, let alone actually could. But certainly, if you the short answer is yes. But I'd still prefer to put it in the context of the circumstances of the time.
Well, just to see that he was Chief Justice when Anne McClellan was Justice Minister, I remember.
Yes.
Who is now the Chancellor of Dalhousie.
Yes.
And she had an opportunity when several vacancies became available on the Supreme Court to appoint an Indigenous or an African Nova Scotian, never did.
Indeed.
And
right.
at that occasion, I was at a rally with Gus Wedderburn out in East Preston, as well as present with an editorial board of the Mail Star. And I can remember the Mail Star issuing a very provocative editorial supporting black judges to Nova Scotia Supreme Court. It never happened.
Indeed.
And I just question what role. He wouldn't have had a role because it was a political appointment. But by the same token, he might have said something among his colleagues or
Quite so. Quite so. I don't want to be guilty of claiming too much for him. I am writing a biography, not a hagiography, and it's I had the privilege of knowing him, not in, of course, in a legal context, and that, of course, one cannot help but be affected by personal contact with people of that caliber. But your point is well taken. I think he was moving one step at a time and doing what he thought was doable. I mean, well, you know, to have 2 women appointed to the Court of Appeal, you know, was certainly considered to be a very significant achievement at the time. Now, of course, we've had a woman Chief Justice of Canada, so we take it all for granted. But at that time, it was a very different thing. But if you look at the big picture, and you know, again, that's part of the context of the big picture of what I mean. You know, his term ended in 1998, and that was then, and this is now, and one has to, you know, to be, you know, to put some appropriate comparisons in place, and just look at the broader context, and indeed what has happened since, you know, since the end of his tenure.
Constance Gluby was not just a woman, she was a Jewish woman.
That's true.
Which is another major achievement, I
Quite
suspect.
so. Quite so.
She was also the woman overruled by the Supreme Court of Canada in the RDS case.
Indeed she was.
Which overruled her, well, apparent prejudice.
I was most interested in discussing that case. Unfortunately, even though Clarke was Chief Justice at the time, he did not participate in the case. So I was not able to, important as the case is, and I might just mention that Constance Backhouse, whom I greatly admire, is, I believe, writing a book about that case as we speak, so that will be...
There's already a University of New Brunswick review article by Carol Allward on that case.
Oh, splendid. Well, I'm
very definitive, I would say.
I'm delighted to hear it. Yeah.
Other questions, comments, queries, or inquiries? Yes, sir.
Did he have any interests outside of the law?
I have been reliably informed that he didn't, that he had no hobbies. And he worked very hard, and my sense is that he worked all the time, or appeared to work all. He was a very hard worker. He had grown up on a farm and certainly worked hard when he was a youth and when he arrived at university. He was a hard worker, and certainly my sense, and of course I cannot speak from any degree of personal knowledge, and I haven't even liked his life, but certainly my impression is that you know, his life was his work.
One of his other interests was this society.
Indeed.
And in fact, he served on the council of the society for a year or two.
Good.
And I had the pleasure of inviting him to do so.
Yes, splendid. Thank you. Yes.
And were you disappointed?
I wasn't disappointed.
You don't express disappointment to judges of the Supreme Court.
I think there's a question behind you, John. No, I'm sorry.
Just curious, in the Buchanan era, one of the conservative influences was someone known as Pugwash Joe. Did Pugwash Joe know Malagash?
Look, that will be a chapter in the book, and I would really rather not go into it here, or it'll never get out. But the short answer is yes, John.
Barry, I'm interested in the trajectory of his career.
Yes.
Because he obviously was considered to be a highly promising legal scholar.
Yes.
To be made a tenured professor of Dalhousie when he was under 30.
Yes.
And he went on to do an LLM
at
Harvard, which would indicate that he might have thought of continuing in an academic career. Is there any particular reason why he left Dalhousie at that particular point?
There is.
To go to a law firm?
There's a very good reason, and there is some debate about it. And you know, I don't know how deeply I want to go into it, Henry. It's a large question. It's decisive for his career, obviously. I mean, we have evidence that he had told the dean of the law school that he wanted to spend his career as a law teacher. Well, a short time after that, you know, he was sending in his letter of resignation. So obviously, for a historian, a biographer, there's a big question there, and you know, I'm attempting to answer it. So we'll see.
Buy the book.
Well,
All will be revealed.
Well, I'll do my best, and we'll see what the
I
public.
take it that this is something that you're looking into.
Very, very closely, because it was my first question: why? Now, lots of people have advanced theories, none of which I actually agree with. Now, obviously, I did not speak to the late former Chief Justice about these matters, you know, and one can only hope that he would not disapprove of what the work we're engaged in. But you know, if you are working on a scholarly biography, by which I mean one that conforms to professional historical standards, you know, you can't get away with not addressing the big questions, you know, and that's the biggest question of his early professional career.
Barry, I knew him greatly as well, and he doesn't seem like the kind of person who would leave papers. He probably didn't leave a great deal of
Unfortunately, I don't know whether, is Colin Clarke in the audience? He is in the audience. Thank you for attending, Colin, and I hope you don't feel that I'm treading on your territory. I do thank you. This is Colin is Chief Justice Clarke's younger son, and I'm very grateful for his. I would not be working on this book were it not for Colin. And certainly the Chief Justice left some material, very valuable, extremely valuable. My sense is not he didn't leave very much, but what he did leave has been extremely valuable, and Colin and his siblings have been very generous in making this material available to him.
Do we have other questions or comments? If not, it's up to me to officially thank you, sir, for...
Thank you, John, for the opportunity. I'm very grateful.
It's up to me to sum things up. Remember, Rosemary's at the back. She'll take your money, whether you want to give it to her or not. And the Genealogical Association material is there for you. I'm reminded of Tony Mackenzie's story about the woman who told him, or was known to have said, that she often noticed that if she didn't die in February, she didn't die at all that year. So I expect you all to be back here in March for the next session. And with that, we stand adjourned. Thank you very much.